There's even an area around marriage and relationship that is not really explored in Nigeria, like breach of promise to marry.
Oh, wow.
Yeah, there can be a breach of promise to marry when there is an unequivocal promise to marry and then the other party breaches it. Maybe, if you propose to a lady, you say, I want to marry you and all that, and then she say, yes. And other guys are coming and say, no, I've gotten this person I'm going to marry. Suddenly the guy says, no, I'm not going to do this anymore. He has caused her a lot of pain, a lot of trauma, maybe even a lot of financial losses. So she can sue, or he can sue, as the case may be. But we don't really explore that a lot in Nigeria.
Yes. Yeah.
Maybe you find a person that maybe you loaned the person money to, say, pay his house rent, and you ask the person to pay. Maybe the person promised to pay on a certain date, and the person could not pay because maybe the person's wife or child became sick, and he kept on saying, please give me some time. And you find out that normally some people will go to the police, report the matter to the police, and the police will go and arrest the person, lock the person up for the person to pay that debt. Now, in that case, you're just using the police as a debt recovery agent, and that is not supposed to be so. That's not.
And the police is not a debt recovery agent.
Their primary responsibility is investigation and prevention of crime. Today, I was trying to make a transfer on my app, and it just didn't work. So if that embarrasses me and I'm unable to fulfill my financial obligations, I could sue the bank. That's a dispute because I'm their customer. We have a relationship.
Can I sue my government?
What should be instead is a class action.
What is a class action?
A class action is an action that is...
Thank you for watching The Yellow Mine. I'd like to invite you to help us reach 1,000 subscribers. Also, like this video and share to your friends, and let me know what you think in the comment section. Why does the office of the senior advocate exist?
It's similar to what is obtainable in the United Kingdom, where we have the King's Counsel. Now we have a king, so it's King's Counsel. And when we had Queen Elizabeth, it was Queen's Counsel.
Okay.
And the idea is just to give a kind of privilege to some people that have been able to attain a level of, shall I say, expertise and achievement in the profession.
Okay.
But it's called a privilege. It is granted by the Legal Practitioners Privileges Committee. Okay. Because indeed there are other people that equally qualify for the rank, but they are not conferred with that privilege. So the aim of creating that rank is to make lawyers to aspire for, to press for excellence. Okay. Now, when you know that there are certain privileges that are attached to that rank, and you need to attain a certain level of excellence, or you have to attain a certain level in the ladder in the career, then you would want to put some energy in getting there. So it's a kind of a motivation for lawyers to drive for excellence.
I've always questioned why they should exist, because nowadays a lot of people are senior advocates of Nigeria, and people who have money usually go for a bunch of them, and it's so intimidating to have like a group of senior lawyers on your side, and then the other person who cannot afford a senior lawyer. And why do they cost so much?
We have this thing about seniority, experience, skills. For instance, if you're into, let's say, photography, there's a level of proficiency that you may attain, and so for a shot you might charge, say, 5,000 naira. But there's another person that has not attained your level of proficiency, and for a shot the person might charge 8,000 naira. Let's say for a lawyer that is below 10 years, the person might not be able to charge as much as a lawyer that is above 10 years. And also, so for a person that has been able to attain the rank of a senior advocate, there is a way that, or there is a benchmark or a minimum threshold for the person's fee, and usually they are even defined by the scale. We have scale of charges. Yes, and the scale of charges is graded according to the age of the lawyer.
What's that scale like? Can you walk me through?
It depends on the matter. If it's like a landed matter, incorporation of companies, civil litigation, civil appeals, criminal litigation, criminal appeals, and all that. So they are there and they are all scaled up. It's not something that I can really like tell you, okay, this is a scale for this, for that, and for that. But whenever I'm dealing with a case, I go to the scale, I look at it, and I know that for my age in the bar, I cannot charge below this.
Okay, so there's a scale.
Yes.
Is it an open secret or is it like a secret?
No, you can download it. Legal Practitioners Remuneration Order 2023. That's the recent one.
2023. So
yes.
In the 2023, let's say
So you can download it. You can look at the scale. You can see what it looks like.
So can we pick like one? Let's say I have a land issue and I'm engaging a lawyer that is 5 years in practice.
Yes.
What is the scale going to look like? I'm not saying
I might not be very accurate.
Yes.
First of all, you're looking at a land issue.
Yes.
And you're talking about a dispute as to title, right?
Mm-hmm.
Because if you're looking at a land issue, there is something about maybe if you're just purchasing the land and you need services of a lawyer to prepare the deed, to prepare the agreement, to register it for you so that the ownership, the legal ownership of the land will be on you. It's a different transaction entirely.
Yes.
And then another one is maybe there is a land dispute as to ownership. This person is saying I'm the owner of the land, the other person. So that's a civil suit.
Yes.
So if a person is about 5 years or so, professional fee, I think, and then it depends also on the states. We have band 1, band 2, band 3. Band 1 states are mostly states in the northwest, northeast, southeast. Then band 2 states are states in the north central, southwest, south, I think. And then band 3 states, just 2 states, actually Lagos State and the FCT. So your fee, what you can charge in Lagos as a lawyer of the same age is different from what a person in Jos can charge.
Because of the standard of living in Lagos.
Because of the standard of living, the cost and all that. So it would be somewhere around 600,000 naira professional fee.
Okay.
Now there are different types of fees. We have professional fee. We have
filing fee.
We have appearance fee. That's money you pay to lawyer. We have appearance fee. Of course, we have out-of-pocket expenses or what we call disbursements, professional disbursements. If the person is going to pay for XYZ, it should come from you. That money that is called professional fee is the money that you're paying to the lawyer as fee for conducting the matter. So, of course, there will be other sub-charges around appearance fee and all that, out-of-pocket expenses. So I think it should be around 600,000. But to be more certain of the amount that I'm talking about, you can Google and download Legal Practitioners Remuneration Order 2022.
Yeah. So what constitutes a civil lawsuit versus a criminal lawsuit?
Yes. So, any dispute between two individuals that does not border on criminality is a civil suit. Sometimes it could be a tort, what we call tortious liability. For example, if somebody while driving his car, he was driving recklessly or negligently, and then he hit your car, and you want to claim some rights. Maybe he has an obligation to fix your car and all that. So that could result into a dispute. It's a civil dispute, but it's tortious in nature. That is a tort. It's a species of civil wrongs. Then we can have contractual disputes. We can have land disputes. We can have any disputes between two individuals. And when I mean individuals, they could be natural individuals. They could be corporate entities. It could be that you have your company and you entered into a transaction with another company and here is a dispute. It could even be between you and your bank. For instance, today I was trying to make a transfer on my app and it just didn't work. So if that embarrasses me and I'm unable to fulfill my financial obligations, I could sue the bank. That's a dispute because I'm their customer. We have a relationship. So disputes, civil disputes are disputes that come up in the course of human relationship. We have matrimonial disputes. People that probably get married and then they have issues in the marriage and they go to court to sort out those issues. There is even an area around marriage and relationship that is not really explored in Nigeria, like breach of promise to marry.
Oh, wow.
Yeah. There can be a breach of promise to marry when there is an unequivocal promise to marry and then the other party breaches it. Maybe, if you propose to a lady, you say, I want to marry you and all that. And then you say, yes. And other guys are coming and say, no. I've gotten this person I'm going to marry. He's giving me his word and all that. And he said no. And then after preparation, and everything and just getting ready for the event. And then suddenly the guy says, no, I'm not going to do this anymore. He's caused her a lot of pain, a lot of trauma, maybe even a lot of financial losses. So she can sue, or he can sue as the case may be. But we don't really explore that a lot in Nigeria.
Yes.
But in Western climes,
yes,
you find.
I figured if someone says I'm opting out of a wedding, there must have been reasons, right? And which the law court will go and determine whether the reasons are valid or not.
Whether the reasons are sufficient.
Yes.
For instance, I know of some people that are applying to get married, and when they checked their genotype, they found out that they were both AS, and it was not advisable for them to marry. So it was like in their best interest and the interest of their children, the children that they were going to be giving birth to, their unborn children, that they decided we have to call off this marriage. And then sometimes again, when let's say the relationship was based on misrepresentation, falsehood, the person said, oh, I work with Zenith Bank and the manager at Zenith Bank, and maybe the person is just a clerk there. And the lady said, okay, I'm going to marry you based on that. And she discovered later that he's just a clerk. So, she can call it off because it's based on misrepresentation.
Okay.
But when there is no sufficient reason on the part of the person that is calling it off, where there is a clear and unequivocal promise to marry, then you can maintain an action, breach of promise to marry. But we don't explore it. So we're just talking about civil suits. So that's, a class of civil suits. Even fundamental rights. When police just arrest you, you're maybe somewhere just hanging out with your friends, and police just comes and arrest you without telling you what you did and locked you up for some days, and after some time they ask you for money, and that's a breach of your fundamental right, and you can go to court and seek redress and claim damages and all that. So, but when we're talking of a criminal wrong, there must be a law that defines the offense, says what the offense is, gives us the elements of the offense, and then prescribes a punishment for that offense.
Okay.
That's now a criminal wrong.
Yeah. Let's say I gave an agent money to get me a house.
Yes.
And they never got me the house. And it's months down the line, and they didn't give me my money back. Okay. Is that a civil lawsuit or a criminal lawsuit?
It depends.
Okay.
So usually what a lawyer would do is that he's going to have a client interview where he's going to discuss with that person to understand why didn't they get the house? You paid them as agents to get the house. Is it that they've been looking for houses and you've not been satisfied and they got exhausted, they couldn't do any thing further? Or is it that they just converted your money, they just misappropriated, they just collected your money and they went their way? So depending on how the lawyer sees it, depending on the outcome of the client interview, it could be criminal misappropriation, where from the beginning there was an intention on the part of the person acting as agent to just collect that money and convert it to his own use. If you can prove that, it becomes criminal. But if you cannot prove that, then it means it's just a breach of contract, because you had a contract that he's going to look for a house for you, you paid him money to do that, and the person was unable to deliver. So you can sue the person for breach of contract. So depending on what you're able to prove. But once you choose to go the criminal route, there's what we call standard of proof. Standard of proof in criminal cases is usually beyond reasonable doubt. Maybe you've heard that you must prove your case beyond reasonable doubt. So proof beyond reasonable doubt simply means that the standard is higher. But in civil cases, it's usually said is upon preponderance of evidence. So which party is able to give more evidence in proof of his case? So if it's like a scale, if you put the evidence of this party and the evidence of this party, whose evidence is heavier? So that's preponderance of evidence. But beyond reasonable doubt does not mean beyond the shadow of doubt, but something that is almost at the level of certainty that you know that, yes, this person is guilty of this offense. Yeah, so the standard of proof in criminal matters is usually higher than that in civil matters. So it depends on how the lawyer sees it and then what the lawyer wants to achieve. But it is not advisable for you to maybe opt for a criminal suit just because you want to intimidate and harass the person. Because if the person also gets a lawyer, he can seek redress from you for wrongly using the criminal law system against him. For example, maybe you find a person that maybe you loaned the person money to, say, pay his house rent, and you ask the person to pay. Maybe the person promised to pay on a certain date and the person could not pay because maybe the person's wife or child became sick, and he kept on saying, please give me some time, give me some time. And you find out that normally some people will go to the police, report the matter to the police, and the police will go and arrest the person, lock the person up for the person to pay that debt. Now, in that case, you're just using the police as a debt recovery agent. and that is not supposed to be so. That's not.
And the police is not a debt recovery agent.
Their primary responsibility is investigation and prevention of crime.
But is there a problem with somebody reporting such a case to the police, even if? Why I'm asking is, let's say I am an ignorant person to the law.
Yes.
I'm an ordinary person and I don't know what the law says about where to report such incidents. Is it wrong for me to go to the police?
Now, there is this saying that, or this quote that says that ignorance of the law is not an excuse.
Yeah.
So if you take that route and at the end of the day there is liability, your ignorance is not going to be an excuse.
Yes.
Now, it's a duty on the part of police for them for the police to tell you that this is not within our jurisdiction. To advise you, go and get a lawyer.
And go to court.
Yeah. And so sometimes it's good for you to seek counsel from a lawyer, ask the lawyer, okay, what can I do about this? But I've come to find out something quite interesting these days in this age of technology, that a lot of people ask ChatGPT, what should I do? And sometimes it does give them fairly accurate answers.
Wow.
Fairly accurate. I would not say, I think I know that I'm better than ChatGPT. That's all the database, but in my area of specialization, I've checked it. And all the time, I always do more than ChatGPT would do.
Yes.
Because I've been in it.
It's just supposed to be an assistant.
It's supposed to be an assistant. So, sometimes in this age of technology, you have this guy, you can ask that, can I ask you a question? I borrowed money to somebody and all that. So where should I go to? Should I go to the court? Should I go to the police? What should I do? I need to respond. You can even ask it to replay so that you get to understand what you should do. So AI is actually here to assist and to help us. Lawyers are afraid that AI might take their work from them, but I don't think it can.
Yes, I don't think so too. Yeah.
Unless you are not competent. If you're not competent, you're going to lose your job to another lawyer, not to AI. Yes.
I mean, I don't see AI coming to court. Maybe in the future, if they're able to come up with like robots, and then the law allows those robots to practice, then maybe you can have that. But at the moment, I don't see where that comes in.
I know that in other countries, there's this thing about, is it robotic lawyer or something like that? A robot that can go to court and conduct a case. And, the speed and accuracy is amazing. But then you also need to consider some other issues like algorithm bias, because the person that developed that robot has an algorithm and the algorithm could have a bias. So that's a limitation on the part of the robot. Then we also have what we call professional responsibilities. If I'm handling your case, I'll be responsible to you professionally. And so if there is any breach on my own part, if I'm supposed to do something and I didn't do it well, I'm supposed to be able to take responsibility for that action. So in the case of AI, if you have a kind of robot lawyer, so who takes responsibility if the robot malfunctions? Because it's a machine. So if it malfunctions, who takes responsibility? I think the person that developed that thing, like the robotic lawyer, is not a lawyer himself. So it's just about programming. If you know how to program, you can get AI to do whatever you want. So I don't really, maybe 100 years to come, I don't know. Maybe 50 years to come, I don't know. But I think there are ethical issues around using AI, artificial intelligence, to replace human intelligence in the area of practice of law, to completely replace. I think it is a tool for people to be able to take advantage of, to gain more knowledge of the law, and lawyers can also use it to like an assistant to help them to deliver with more speed and accuracy. For example, we have some legal databases like Law Pavilion. Law Pavilion has what we call Prime GPT. So Law Pavilion is a legal database with cases, laws of the Federation of Nigeria, rules of court and all that. And there is also Prime GPT. So if you're researching a case and you're at loss, okay, I can't really fine-tune this, you can chat with Prime GPT, you can ask it a question. Okay, so in this case, I've seen this, I've seen that. What about this? You're looking at another angle of your case, and it can, the way it just depends on the prompt you give it. So it always responds to your promptings. And so AI is not as dynamic as the human being.
Yes.
So you can't take that dynamism from human relationship, and you can't take that dynamism from legal practice. So I really think, for me, I do use AI, but if you take any of my work and you check it for AI, AI doesn't do my work.
Yeah.
It's just my assistant. So I've also had clients that would give me a draft and say, can you review this for us? And when I look at it, I know that it was generated by ChatGPT. I say, okay, right. I know where you're coming from. And when I'm done, they can see the difference.
Yeah.
So, but assuming I don't know the use of AI in my practice, then I will not appreciate where they are coming from and where they are getting those their drafts from. Because you can ask ChatGPT, can you please draft an agreement, an MOU between so company and so company for the supply of XYZ, and it's going to draft. Yeah.
Let's talk about property law.
Okay.
Because this is one of the gray areas in Nigeria.
Yes.
Let's say I'm interested in a property.
Yes.
Maybe a piece of land or a house or whatever it is. What does the law say about my actions? What are my steps? Like step by step, how do I acquire a property?
Yeah. Now, you see, if you're going to go by standard practice, and what I'm going to tell you, I do believe that we have a good number of lawyers that don't follow these steps.
Okay.
But we teach these steps in law school. There are 5 stages in a land transaction. We have the pre-contract stage, we have the contract stage, we have the post-contract stage, we have the completion stage, and we have the perfection stage.
Wow.
Now, let me tell you what it means. For instance, at the pre-contract stage, what you're doing at that stage is you're basically making preliminary inquiries. You're trying to find out some basic questions about land. Okay, the boundaries. You're trying to find out about services to land. Is there electricity, access, road, water, and all that. You're also trying to probably negotiate the price to know if this property is suitable for what you want. You want to know if it's an undeveloped area, if it's waterlogged, if it's a built area. You want to know if there are certain defects on the building and all that. So those are the things that you should handle at the pre-contract stage. That's what you do at that stage. You're making inquiries, you're negotiating, you're deciding whether you want to go for that property.
Yes.
I won't go too deep because it's a lot.
Okay.
If you want to go deep, it's a lot around that. Because we can begin to talk about patent defects and latent defects, which I don't want to go into because it might be too complex for an ordinary person. I don't want to say lay person because I don't like using that word. It's like when you use that to a non-lawyer, it's like, why are you trying to beat me down, make me look like I know? So in the area that I'm knowledgeable, somebody is not. In the area that somebody is knowledgeable, I'm not. So let's just say somebody that is not learned in law. Because I'm learned in law and you know, let's just leave this narrative issue out. I like to just show respect to every professional.
Yeah.
And that's just really. Then you now go to the contract stage. Now you know that you're interested, but you need to make some investigations to be really sure that the person selling to you has the right and the title to pass to you. And so what you do at that point is you pay a deposit, you come up with a contract, you drop a contract, you agree as to terms, when you're going to finish, if you're going to pay in installments, when you how many installments, how you're going to go about it and all that, you sign. And then at that point, there are many things you can do there, but basically this is what is done at that stage. Then you move on to the post-contract stage, which is when you begin to do your investigation. You go to the Ministry of Lands, you go to the court. If the person, you now ask the person to deduce title first of all, and deduction of title is simply to show how this property became his. Okay, my father bought it from this person, then he died so year, and he willed it to me, and the will was admitted to probate, and the property is now mine and all that. So from deduction of title, you now know how to conduct your search and investigation. You go to the lands registry. If, say, there is a will or letters of administration, you go to the probate registry. You go to the court registry to know if there is any pending litigation and all that. So when you're done with your search and investigation and you're comfortable, then you move on to the completion stage where you pay the balance, where you sign the deed of assignment, at that. And then where you're giving possession, you're giving keys, you're giving title documents and all that. Then you go to the last stage, which is perfection. You register that land so that you are now known as the legal owner. So this is just like a run through the 5 stages in the land transaction. But even some lawyers don't do that, and everybody is now selling land.
And this is supposed to be conducted by a lawyer, right?
Yes, this is a lawyer's professional work.
If I'm acquiring a property, the first thing to do is to engage a lawyer.
It's important. It's important. If you feel you are knowledgeable enough, you can go ahead and handle the transaction by yourself, but there are dangers you avoid when you involve a lawyer.
What is a valid contract in this context of property? Let's say me and you have an agreement. I want to acquire this piece of land from you, and maybe we write a contract or we verbalize the contract, and I made payment to you. Is that valid before the law?
Okay. Now we're looking at the contract stage, because I talked about 5 stages.
Yes.
But you can look at them broadly speaking as 2 stages: the contract stage and the conveyance stage.
Yeah.
Now, conveyance is just passing property from one person to another. So that you've paid me money for the property and I've given you the property and you're living in the house does not mean that the property has been conveyed to you. You must be recognized by law as the legal owner of that property for us to say that the property has been conveyed. So at the contract stage, there are different forms of contracts. We have the formal contract, which is usually drafted by a lawyer. Then we have the open contract, and the one drafted by the lawyer, you bring in all the terms.
Yes.
All the you dot your I's, you cross your T's.
Due diligence.
Yes.
Yeah.
And then, but for the one that is open, you're just looking for certainty of property, certainty of parties, certainty of price, and then signature of the parties. So once you have these 3 P's and an S, you know that you have an open contract. So sometimes even a receipt, I, so person received the sum of so amount as payment for purchase price for my property with CFO number and sign. So that can stand as an open contract. You can use it to say. And then you have the oral contract, which generally speaking is more or less when you're purchasing customary land. If you go to the village, under native law and custom, writing is not known to our native law and custom. So usually what they do is that there is payment of the purchase price in the presence of witnesses, and then the person is put in possession. So you are there, you say, okay, I want to purchase this land, you call witnesses. Usually you buy a drink for them, you give them cola nut. That's where we get the IWC. You give them IWC and the witness that, yes, this person sold this property to this person, and then you're giving possession. Say, these are the boundaries, it's now your land, you can do. So under native law and custom, once you have payment of purchase price in the presence of witnesses, and the purchaser is put in possession, is also another 3 P's there. Payment of purchase price, presence of witnesses, purchaser put in possession. So, it also satisfies. But, the problem is when you now want to register that land. Because for you to register the land, you have to have a document to register. So that's where you begin to get into problems. So I advise that at worst, get an open contract. Sometimes when you go to the local government land registry and you want to buy the change of ownership form, they can give you a kind of form that looks like an open contract form. You fill in your details and at least you have something to register. It does not protect you like a lawyer's draft will that contains all the formal clauses. The lawyer knows the dangers around, so he will try to put those clauses to protect you. Yeah. So those are some things. But people don't like paying lawyers. So they try, you don't need that. You come and ask you for 10% and all that. And so you don't like paying lawyers. And so and that's why sometimes some people get into trouble. Some people get away with it. But sometimes the deal might actually go south and you lose a lot of money in the process. What's
the assurance that if I take a matter to court, I'll get justice in Nigeria?
Let me start by saying, if you're complaining of a legal wrong, that is your only option, because the law itself frowns at self-help.
Okay.
Yes, self-help simply means you taking the law into your hands. Let's say if you give your house out to a tenant and the person doesn't want to go out after his rent has expired, and you're giving him all the notice and the person doesn't want to go out, you should not now come and force yourself into the house and throw him out. That's self-help, and that can actually make you to incur liability. So first of all, I'll start by saying that's your only option. There is this saying that the judiciary is the last hope of the common man. So in other words, if somebody has wronged you, no matter how high and mighty the person is, when you go to court, you should get justice. Coming to the Nigerian system, well, I'll say we don't have any other option. That's why we have to keep putting pressure on the judiciary to make sure that justice is dispensed. Nevertheless, one of the things we must understand is that it's human beings that we have managing the process, and sometimes people are bound to make errors. A lawyer can make an error in conducting a case. A judge can also make an error in delivering judgment. And that's why we have the appellate court system.
Okay.
Yes. So if you maybe start your case at, let's say, the High Court, and you're not satisfied with the judgment of the judge, you're going to write, or you're going to draft or get your notice of appeal filed in the Court of Appeal, where you state your grounds of appeal. You say whether the court erred in law, whether the court misdirected itself or whatever, and you're going to give the particulars. So if you feel dissatisfied, if you think that this court ought to have made pronouncement on XYZ, this court ought to have looked at this evidence that I brought, but the court didn't do it, then you have the right to appeal. So you have levels and levels of appeal up to the Supreme Court. So that's just basically
So
it.
Any case can get up to Supreme Court?
Yes, any case can get up to the Supreme Court, with the exception of like election petition, when you're dealing with cases that emanate from election of members of the National Assembly and the state assemblies. The limit is the Court of Appeal. And of course, it doesn't mean that all cases must get to the Supreme Court. There are certain cases that do not have to get up to the Supreme Court if you're satisfied with the judgment of the court, even if you're the person that lost. For example, I can tell you I did one case at the High Court of Plateau State, and judgment was entered against my client. First of all, when he came to me, I advised him, I told him that this your case, there is a narrow chance. There's only one angle I'm looking at, because the case wasn't a very good case. And I told him candidly from the beginning. And you see, it's my duty as a lawyer to advise my client candidly. I told him that candidly, this your case, there's only a narrow chance. So, but most of the odds are against you. So if you go to court, it simply means that we want to exploit this little chance that we have. He said, let's go. So we went to court, and the judge rightly entered judgment against us. I'll say rightly but I felt he didn't consider something that we raised. And so I said, well, I agree with the reasoning of the judge, but I disagree with him. I'm not satisfied because he didn't address such and such an issue. So I appealed, and I said, the court did not address such and such an issue. So we want the Court of Appeal to address those issues. And they delivered judgment. They said, yes, we're now considering such and such issues. And they gave their reasons, and they resolved it against us. So the client told me, should we go to the Supreme Court? I said, no, I'm satisfied with the judgment of the Court of Appeal.
So as a lawyer
now, so it's not a win at all cost.
You
see, that's the problem that I think some lawyers have. When you take a case from your client, it's not a win at all cost. Your duty is to advise your client according to the law. And when you see that justice is done according to the law, you should learn to accept. It's people that want to get the law to do their biddings at all costs that begin to cut corners. But once you are satisfied for justice to be done according to the law, in other words, if it is my right to get this remedy, then let me get it. But if it is not my right, then I'm not going to insist. But some people want to twist the court to get what they want at all costs. And that also puts pressure on the court. They maybe use friends and family, use blackmail, use all manner of things to get a court to dance to their tune. So that is part of the problem that we have.
So as a lawyer, do you have the right to reject a case? If I came to you and say, represent me, and then you looked at my case and you saw that I was clearly in the wrong, do you have the right to say, no, you're not going to represent me?
Now, we have something that we call the cab rank rule, which is the duty to accept all briefs.
Okay.
But there is an exception to the cab rank rule. I can accept your brief, study your brief, and of course, accepting your brief, listening to you, studying to you, I will charge you for that.
Okay.
We call it briefing fee. Some people call it consultation fee. And so after doing all that, I will give you opinion. So when I give you my opinion, and you're not satisfied with my opinion and how I want to conduct the case, then I must excuse myself from the case. Because you cannot force me to go about a case in the way that is not ethically right.
Okay.
Yes. So that's the ground for me, because I cannot aid the unlawful practice of the law or the improper practice of the law. So you want me to do something that is not in line with the law. For example, you want us to maybe fabricate some documents to prove your case, because there are pieces of evidence that we need to prove your case, and you don't have those documents, and you feel, let's go and fabricate the documents so that we can make up your case. For me, I won't do that. I don't do that. But of course, there are lawyers that do it. To be candid, yes, there are lawyers that do it. I've been in court with opposing counsels and they brought forged documents. And it was a duty on my own part to prove that those documents were forged.
Yeah.
I know the thing is that after proving it was a forgery, if I like, I can take it up to say, okay, who did the forgery? So it's a lot of, I must tell you the truth. There is a lot of, let me put it this way with some level of caution. There is a lot of dirt in the legal profession and we need to begin to clean. And we that are in the space, lawyers and judges, we should start from ourselves. First of all, as a lawyer, don't put pressure on the judge. If I have friends that are now appointed, I have classmates and friends that are now appointed into the judiciary, even the higher bench, high court and all that. And I try to give them some safe space.
Okay.
What I mean by safe space is space for them to do their work without interference. But when I now want to begin to leverage on my relationship to influence them, to make a decision one way or the other, to put pressure on them, might not necessarily be giving them any money like bribe or something like that, but that is obstructing them in carrying out their responsibility. So I think we must start from that point, that as lawyers, when your classmate is appointed a judge, he's not there to give you orders as you wish.
Yeah.
You understand? Yeah. Let me quickly just say a little about, like, let's say, take the case of River State now. That people are saying that the minister of the FCT has judges doing his bidding. He's a lawyer too, has judges doing his bidding and giving him orders as he pleases. I don't have facts to prove that. But should that be true, he is actually exerting undue influence on them. He should allow them to do their work. Judges are supposed to be very conservative. Yes, they are not supposed to mingle with people anyhow so that they can do their work without interference. And I think we need to ensure that they have that safe space to do their work.
Yeah. So let me take you back a little. What are the types of courts in the Nigerian system and what are their functions, starting from the lowest court to the highest court?
First of all, let me say it depends on the subject matter of litigation. Two, we can also categorize them as courts of superior records and courts of inferior records. Now, let's take in Plateau State, for example, we have the area courts.
The area courts?
Yes.
Okay.
We have the area courts. We have them in grades up to the upper area court.
Okay, so there's the lower area court.
There's just the area courts.
Okay,
we have grade 1, grade 2, grade 3, then we have the upper area court.
Okay.
Now, these are courts that have jurisdiction on matters of native law and custom.
Native law and custom.
Yes.
Okay.
Then we have the customary court of appeal. So if you're appealing a decision from the upper area court, if you're not satisfied with the decision of the upper area court or the area court and you want to challenge it, you go to the customary court of appeal.
Okay, so native law and custom, what kind of cases do they handle?
Now, let's say, okay, let me give you an example of one that I'm thinking of filing very soon. Let's say this person died and he has several children and they are all claiming certain inheritance rights and there's a dispute. So you go to such courts.
You go to an area court.
Yes, area. Okay. In some other states, they call these same courts customary courts.
Oh, okay.
Yes.
Yes.
Like in Kaduna State, they call it customary court. So you may find some states are calling it customary court, but in Plateau States, they call it area court.
Okay.
So, but then when we are also looking like maybe small claims, landlord, tenant, small money claims and all that, you go to district courts. That is what is also called magistrate court.
Yeah.
The same court sitting in a civil matter is called district court. The same court sitting on a criminal matter is called magistrate court.
Okay.
Yes. So there are certain offenses that the punishment is not be above a certain term of years in prison. You can institute the case in a magistrate court. There are some small claims, maybe 1 million, 2 million, claim like that, you can institute it in the magistrate court. Landlord and tenant issues, you can institute in the magistrate court. And then you now go to the state high court, which is a court that has a court of general jurisdiction. Okay. You can actually, except for those excluded by law. So every other dispute that you have, you can, civil or criminal, you can file, you can take it to the state high court. But we also have the federal high court. The state high court is similar in jurisdiction with the high court of the FCT. We also have the federal high court. And the jurisdiction of the federal high court is spelled out in section 251 of the Constitution. Maybe things around Companies and Allied Matters Acts, things around revenue of the federation, disputes between, concerning the decision of an agency of the federal government, and so on and so forth. So those are disputes that you take to the Federal High Court. And then if you're dissatisfied with any decision from the State High Court, from the Federal High Court, from the Customary Court of Appeal, from the National Industrial Courts, National Industrial Court has to do with disputes around employment, employer, employee, and all that. You can appeal to the Court of Appeal. Is one Court of Appeal with several divisions. Then if you're dissatisfied with that decision, you can appeal from the Court of Appeal to the Supreme Court. So I think in a summary, this is just about the basic of the hierarchy of courts.
How many judges sit in an appeal?
Like in the Court of Appeal, we have 3.
3?
Yes.
So usually an odd number?
Yes, usually an odd number. In the Supreme Court, we have 5, and then there are certain appeals that you have 7.
Okay.
Yes. So it depends on what the issue of appeal is and what the and the nature of the appellate court.
Yes. Nigeria is a country where when you lose an election, the first instinct is I'm heading to court.
Yes.
Probably because of the way our election systems are here.
Yes.
We in the ordinary people, right? You guys are the learned in law.
Okay.
We, the ordinary people, believe largely that justice is always miscarried when it comes to elections.
Yes.
And I'm afraid to say that is what forms our general perception that the judiciary is flawed and there's no hope. You spoke about the judiciary being
as
the last hope of the common man.
Yes. So
what do you have to say about that?
I have a friend, a colleague, who actually sometimes in a joking manner says that the judiciary is the lost hope of the common man. Sometimes I look and I say, really? And then I have another friend who is also a lawyer. Incidentally, he says, he normally says that the judiciary is the last hope of the executive.
Oh, yeah. That is a very, very, very good observation.
Yeah, so these are strong allegations against the judiciary. And I'm not here to exonerate them or to substantiate that allegation. I do believe that there is no smoke without fire. So if you hear people complaining, it's because probably it has actually happened. I want to be a little bit careful, but sometimes too, there are some cases that I conduct, and I think that this case is in black and white. But when you see the outcome, you wonder, what is the reasoning of the judge? Because for a judge, at a certain level, you expect that he is sound in the issue of law. And you don't expect the judge to make elementary errors. And so sometimes when I see that, I really wonder, I say, do you mean this judge doesn't really understand these concepts? But anyway, that's why we have appeal. Let me start by saying, before an election is completed, you have somebody saying, go to court.
Yeah.
It raises a big question. People are complaining. The last election, let's just play back and remember what the facts were. Results were not seen on the IREV. And people were complaining that results were tampered with. And the promise that INEC gave Nigerians is that we're going to be able to view results at the polling results real time. You can find that for certain polling units, you find the senatorial House of Reps, but for presidential, it's not there. People raise an eyebrow.
Yes.
I think
and for some, it even took days.
Yes. Yeah. I think what an objective INEC should do is to hold on, because there was a request to hold on with the coalition. Now, I don't belong to any political party. So I'm not siding any party. I may have my political views, but that is not partisan. But instead of INEC to do what is objective, you find them saying, well, let's go on. And somebody is saying, well, if they're not satisfied, they can go to court.
Oh, yeah.
Yeah, because that's what happened. So if they are not satisfied, they can go to court. Some people even stage the walkout and say, well, they can stay out if they want to. And they can choose to go to court. I think we shouldn't have, that scenario shouldn't have played out the way it did.
The source of the demand to hold on, does it really matter? So let's say I am a delegate, or maybe just an ordinary citizen who casted my vote, and I'm raising an allegation and I'm saying, hey, hold on, because I saw this.
Yes.
Does it just give me the right to just command INEC to hold on?
Now, of course, as an ordinary citizen, you cannot go to the collation center and do that, because it is restricted. But if you are a party agent, and let's say the result that was brought by the officer, I don't know, the returning officer, is in conflict with the result that you received from your agent.
Yes.
You need to say, well, we have this conflict. We need to resolve it.
Yes.
If, say, the computation is not correct, you can say, we have this problem, we need to resolve it. If there are results that do not tally with results that are, from the maybe ward, local government,
and the state,
and state, you need to say, okay, we need to look at this. And what INEC should do is to look at it objectively. And if they are going to step down that to consider it later, they should. You understand? That is if it is done objectively. When elections are substantially free and fair, not devoid of any form of malpractice, then you will not have people going to court. When we are talking about even challenging an election for non-compliance, the ground is usually substantial non-compliance. So substantial non-compliance means that the non-compliance is of such a degree that could change the outcome of the election, that the result could have gone another way. So, but when the election is substantially compliant, you not have people going to court. The US just completed their election. Who is going to court?
Nobody.
So why is it that almost after all our elections, people are going to court? And because they are dissatisfied with what INEC is doing. But the problem we have with INEC is fundamental. And there are people that are talking about certain reforms around INEC. Who nominates the INEC chair? Is the president.
Yeah.
So, and then he is a politician. He is partisan. He has his own interest.
Yeah.
And so I think we should have a neutral process of selecting the INEC chair. I'm also of the opinion that even our judges, we should have a form of election like they do in the US.
Yes.
It shouldn't just be a selection, a nomination by the governor of the state or nomination by the president and all that. That is how they now are able, or people now accuse them of having some of these judges as their political assets.
But even in the US, the president nominates judges into the Supreme Court, and I think Court of Appeal as
yes, well. But I don't know the details of that, but I think there is also an election process. So I think there can be a nomination of a certain number. Let's say we need 5 judges. You can nominate, say, 8, 9, or 10. I don't know the actual procedure.
Yeah.
Then there will be an election. So in other words, the president doesn't have the final say.
Okay.
But when you have a kind of selection that is more or less like when this person goes to the National Assembly, you just be rubber stamped. When this person goes to the NGC, you just be rubber stamped and all that. So you just have that the governor got you and he just said, don't worry, you're going to get there, and the person goes there. Then the person can become his political asset.
Yeah, he has to do the bidding.
Yes, so, so that's the problem that I think, because justice must not only be done, but it must be seen to be done. So there should be this neutrality and transparency around the appointment of judges and the INEC chair, so that these people are free from influence by politicians. So I think that's the beginning. And there are a lot of people that are talking and writing about reforms in that area. And I do agree that we should have reforms in that area. Nevertheless, we usually say that we're ministers in the temple of justice, and the judge is the Lord, my Lord. We call them my Lord. And so whoever are nominated, even if you were nominated by somebody today, I can tell you, I don't want to be a judge. I'm not applying for. I've never applied for, and I would never.
Wow.
Maybe if I'm put under pressure, because I don't want to live their kind of life. They are too conservative. I don't think I can live that kind of life. If I'm put under pressure and the pressure is too strong, maybe I would give in, but I'm not thinking of it.
Okay.
I'm in academics. I want to be a professor. That's all.
But don't you think we need people who are passionate in that place?
Yes, we need people who are passionate. Just like we also need people who are passionate in academics. We also need people who are passionate in practice. So if a person's wiring is for the bench, then he should go. If a person is normally conservative, but if I like mingling with people, I like talking, I like going in and out, I shouldn't be a judge.
Yeah.
So I don't think I'm the kind of person that should be a judge. I don't want to be.
So basically what you're saying is the problem with elections is not just about the outcome in the court, but it's fundamentally from the system.
From the system.
Yeah.
From the system. So if we get it right, when the people can actually determine who gets to power, then the politicians will begin to behave well.
Okay.
But when a politician knows that all I need to do is to buy police, buy INEC, buy the judges, and I'll get to power, then the person doesn't care. All he needs to do, the security agencies, bribe them. The INEC, that's the election empire, have them in your pocket, and then also have the judges in your pocket. So it looks like people feel that is what is happening. But I will not say it doesn't happen. I will not say it does. But I can tell you that there are a number of election cases that were decided on the merit. Yeah.
I started going to court to sit down, just to listen. Whether I am a party to a matter or not, I just go sit down and take note of what is going on. And I must say that my thinking about the Nigerian society changed dramatically, because I sat in cases, and most of the cases I sat in were drug cases.
Okay.
And for me...
Was it the Federal High Court?
Yes, the Federal High Court. I frequent the Federal High Court more. And for me, I saw something about the other side of Nigeria that I didn't know existed. I didn't even know how big drug is until I started sitting in court. So I often tell people, you need to find time at your spare time, just go sit in court and watch the drama. Yeah. You will learn so much.
Exactly.
You'll understand that it's not just about the facts you have, but how your lawyer is able to even present
it.
Yes, and I watched some lawyers were very brilliant in their presentation, and some not so brilliant. Even I could do a better job.
Yeah, I would agree. You know, when I was in university, one of my professors said that there are 3 P's in practice. That is preparation, presentation, and persuasion. Wow. So as a lawyer, before you go to court, you must be prepared. You must study your case very well. You must have your facts. You must have the law at your fingertips, and you must also study the case of your of the opposite side very well. Then you must also do a neat presentation. Your presentation should be clear, free from ambiguity. The court should be able to know what you're saying, understand you clearly, and then you should have a level of persuasion. Your presentation should be compelling. You should be able to persuade the court to see the matter from you. So if a lawyer doesn't have these 3 P's, the presentation is going to be sloppy, and then sometimes it could affect the case of the client. Sometimes it also has to do with the age of the lawyer. Maybe let's say a lawyer is just a year or 2 in the bar. Yeah. He's going to court and he's shaking and he's all that, and there's a very experienced lawyer, so the person loses confidence. So that's why I usually advise that when a lawyer is quite young, you start with basic things. Just go and move this motion, just go and do that. Just basic things. And then when the matter is coming up for something that is contentious, make sure that a senior goes along with that lawyer so that he sees how the senior does a presentation. That's mentoring. That's coaching. So I think, and then that's what we call pupillage. But some people come out of law school after NYSC 1-2 years, they want to set up their law firms without doing some level of pupillage. That is a problem.
Yeah. Why does it take time for justice to be served?
Well, first of all, let's look at the volume of cases we have in court. We have a lot of cases in court. People are filing cases on a daily basis. 2, let us also look at the recording system. I don't know, maybe the Federal High Court you attended, probably I think the judge has a stenographer.
Yes, she has a stenographer.
So that is an innovative judge.
Yes.
But most of the courts we have, they don't have stenographers.
Yes, when I went to the State High Court, it was the judge that was taking notes. Yeah, I was confused because, in fact, one of the lawyers had to instruct the witness to take it slowly. Yes, so that the judge can write. And the judge took note of everything that was said in court, and I was like, wow.
So you can just imagine the time that is taking. But if he had a stenographer, the witness will just keep talking and the stenographer is doing the work, and later so it makes the work of the judge easier and faster. So that's 1. 2, we have to also look at, even though now there are limits to, there's a limit to the number of adjournment. A judge cannot just keep granting adjournment upon adjournment and all that. Lawyers also try to take that as a employ to delay a case when they know that they don't have a good case.
Yeah.
So they take to delay tactics. But if the other lawyer is on his feet and is always pushing, then he'll be able to fast track the matter. Sometimes you can even apply for accelerated hearing.
Oh, wow.
Yes, especially if the subject matter is one that
It's
deserves
time-bound.
that. Yes, maybe it's time bound. If the court doesn't make a decision within a certain period of time, then the aim of justice might be defeated. Then you can apply for accelerated hearing. Or cases that have lingered in court for too long, you can make a case and apply for accelerated hearing. In that case, the court can fix like 3 consecutive days for that matter to come up. Let's say 18th, 19th, and 20th of November. So, you know, and the court can also say, bring all your witnesses within that period. You know, so there is a lot that judges can do by way of innovation in their courtrooms to try to see that they deliver justice faster. But I think we need to do a lot around, but a lot has been done too. We have practice directions now that require witnesses to file their statements on oath. So the only thing that will be done in court is going to be cross-examination. So, you know, and all that. So there's a lot of innovation going on around that, but I think we can still do more. If we can finish election petitions in 6 months, so why not let's look at the rules and try to see how we make that better. I think there's still more that can be done, but we're not where we used to be. In the past, in the High Court, you could have a matter going on for 15 years.
15 years.
Sometimes even more. So
the judge can die.
If a judge
or
dies,
retire.
It's now assigned to another judge and he has to start afresh.
Afresh?
Yes. Wow. Start afresh. You know, so those are some of the challenges, and I think we need to really think of innovative ways to circumvent all those challenges so that justice is delivered and delivered fast. Because as they said, justice delayed is justice denied. So I think we have a lot of growing up to do in Nigeria in that area.
Yeah. So let's say I am about to file a case. What should I consider? Or should I just, once I have a dispute with someone I want to settle it, can I just quickly go to court, or should I seek an alternative dispute resolution first before just going to court?
Yes, thank you very much for bringing up the issue of ADR, alternative dispute resolution. You know, most of the rules of court now require mandatory pre-action counseling. And that pre-action counseling means that you must lay all the options open to your client.
Okay.
The client must understand that there is an ADR option. In Plateau State now, like in some other states, Lagos, Federal Capital, Kaduna, and some states, we have what we call the multi-door courthouse.
Okay.
So, in other words, when you come into the court, there are several doors. One door is litigation. The other door is ADR. So there's nothing that says that when you go to court, you even start litigation, that you must end up with litigation. You can choose an ADR option. For example, whenever I'm drafting commercial contracts, I always insert ADR clauses. And so when you even bring a case and you have an agreement, I look into the agreement to see if there's an ADR clause.
Yeah.
So that we invoke that clause and we try to see how we resolve the matter. And you know, if you have a person that knows how to draft ADR clauses, you can actually avoid litigation. Especially when there's an arbitration clause, because the award of an arbitrator is final and is binding. You can only appeal it on one ground: misconduct of the arbitrator. And so I think people should explore that. And one thing I want to say is that the practice of ADR is not restricted to lawyers. Okay. You can take training in mediation. And you can facilitate mediation. You can take training in negotiation. You can take training in arbitration.
Where do I take that training?
There are a lot of institutions. We have Settlement House. We have ICMC, Institute of Chartered Mediators and Conciliators. We have the Chartered Institute of Arbitrators. We have the Chartered Institute of Arbitrators UK, Nigeria branch. So we have a lot of institutions that you can take training. And say you're in entertainment. When there is arbitration around entertainment, you could be appointed as an arbitrator because of your knowledge in the entertainment space.
Yeah.
You know, and all that. So it's not a space that is exclusively reserved for lawyers. It's open. So, and I think people should actually know about ADR and try to also employ it. There is also customary arbitration under Native Law and Custom. People are even exploring it. How can we settle matters using customary arbitration? That's when people go to their chiefs and get them to, you know, try to resolve the matter in dispute between them.
So I have the right to freedom of speech.
Yes.
Does that mean I can just say what I like?
Certainly, freedom of speech means you can express your opinion. I'm using my freedom of speech now. But there's also an offense called sedition, which is stirring up people against the government. So if there is a limit to it. So if I push my speech to a point that I begin to stir people, for example, there's somebody that was saying when the protest was going on, somebody went on and said that tomorrow we're going to go and we'll burn this place, we'll burn that. And I heard the news about somebody like that in Jos, and the person was arrested. So if I call people to arms, like the IPOB leader, Nnamdi Kanu, against the government, that's now going beyond the limit of the right guaranteed by the Constitution. So I have freedom of speech. I can air my opinion. I just aired my opinion concerning government's attitude towards protests and the attitude of the police towards protesters. That's my opinion. And it's objective on the matter of public interest. So I'm free to air my opinion on matters of public interest. But I should also understand when that can become sedition, when I begin to stir people against government.
Yeah. So talking about the IPOB, do people have the right to aspire to have their own country?
Yes, it's called the right to self-determination. Even though in Nigerian Constitution we cannot find that in Chapter 4, but the African Charter on Human and People's Rights, you can find that it's a right that people have to self-determination.
So it's more of an international right.
So in that case, we have African court, we have ECOWAS court, we have international courts and all, but that is a political right. But it's not in the Nigerian Constitution that every people have the right to self-determination.
So it's not the fundamental right.
So it's not, you cannot go to court and say, we want you to give us our country, we want to break out from Nigeria. But there is a way you can put pressure on the government. And there is a process like the issue of referendum. This is an area of specialization. Some people actually are very vast in this area because there's supposed to be a process if you want to self-determine, issue of referendum and all that. And you'll find out that in our constitution, we do not have very clear guidelines as to how a people can come together and say, okay, we want to self-determine and want to do it peacefully. We want to have a referendum to get our people to say, like it was done in Sudan. There was a referendum before there was a breakup between Sudan and South Sudan. So I think that's an area that we need to look at. But for now, at least you can agitate. People are still agitating and say that we want to have our state, we want to have the state of Biafra. But the way to go about it shouldn't be by a violent means. There is a civil way to go about it. You can choose to take the route of referendum. You can choose to mount pressure on the government. You can choose to mount pressure on the government through international organizations and agencies. Okay, we've been marginalized over the years because that's their complaint. We've marginalized over the years, so we feel that we're going to develop faster if we're allowed to be on our own. That's the grouse of the Southeasterners. So I think those are some limitations that we have. So if you now say, okay, we are now going to have our own police, we're going to have our own state structure and all that, is going to be considered treason. So those are the limitations. You cannot just begin to operate a state when it is not done according to the process of law. And this is an issue that we'll touch on international law. It's a specialized area, and I don't think I can go too deep into it because it's not really an area of my specialization, but I can say the bit I can say about it.
So last week, or was it early this week, the National Assembly said that every Nigerian child has the right to go to school and must go to school. At least I think this is something that is new, because I know free education has been here for a while, even though I don't believe it's effective because of the quality of education, because free education and quality is kind of two separate things. But now they're taking it a step further to say it's a must. So is it that when the National Assembly passes a law like that, it's immediately applied in the courts, or how do you...
Okay, now the duty on the government or the state to provide education is in Chapter 2.
Okay.
So the idea is to move that particular right from Chapter 2 to Chapter 4.
Oh, okay.
Yes, so if you move it from Chapter 2 to Chapter 4, it becomes a fundamental right.
And that's the job of the National Assembly.
Yes, so the National Assembly can do that, can remove that right from Chapter 2 to Chapter 4. So if they do a constitutional amendment and they remove that right from Chapter 2 and take it to Chapter 4, then people can now go to court and say, provide education for us in our village, provide education for those that are hawking on the street, provide education for the Almajiri child.
Yes.
And it's going to be a duty on the government to expend resources to make these social investments, because for you to provide education, there must be some social investment. But that's the responsibility of government. So when we want to say compulsory, free and compulsory education, that's the idea, to have free and compulsory education. In Nigeria, we're talking about basic education, which is from primary 1 up to JS3, 9 years of education. So it should be free and compulsory. So you cannot compel a person to go to school when you've not provided the schools. So there was this time that SERAP, it's a non-governmental, I believe you must have heard about it.
Yes.
It's an INGO, went to court, an international court, and they got judgment that the government of Nigeria should provide free education to Nigerian children. I think that's the least that any responsible government should do. And you see, I also believe that is one of the ways that we can tackle some of the challenges we have, like issues around insecurity and high level of criminality. I think to a large extent it has to do with low level of education, because if a person is educated, you can create opportunities for yourself where other people are not seeing.
Yes.
I know that some people will say, well, I've graduated, I don't have a job. Then I think we should take your certificate from it, because you should be able to create an opportunity for you. Even if you study, let's say, political science and you don't get a job, you should be able to create an opportunity for yourself to survive in this system. But when you see, let's say, the Almajiri child, and he can't even read and write Hausa or Arabic or English. He's not been to school. Even when they say that they are going to Quranic school, do a survey and find out most of them don't even know how to read Arabic. All they do is they scavenge and they go around begging. So I think as a country, as a nation, we need to deal with that. And I think the National Assembly is doing the right part. That right should be removed from Chapter 2 and be placed in Chapter 4, so that we can begin to go to court and say, in this community, we don't have school. In that place, we don't have school.
Yes.
And then we also need to hold government accountable to make, as to the quality of the education. Permit me to say something. I don't want to ask another question, but I think we should also have a system that checks teachers in public schools.
Yes, absolutely.
Yes, because government can employ staff, give them a good pay, and they are not doing their jobs, and we blame it on the politicians. So that's another problem.
I think one of the problems is the labor unions. In my opinion, the labor unions have not served Nigerians. The labor unions have only existed to fight for the rights of their members and cover up for their members, because it's not just primary and secondary schools, even universities. Yes. You have universities where a professor has never showed up in class.
Yes.
And nothing has been done. And this is one of my grouches with ASU and those other bodies. And I'm like, can you do the due diligence of sieving out the bad eggs among you? And, doing your homework by making sure that your members are held to account, so that when you're demanding for what is rightfully yours, you can be heard.
Yes.
Right?
Yes. You know that you've done your own part. If you look at what a professor is paid in Nigeria, put it side by side with what other professors are paid in other parts of the world. So we have that challenge. Yet it's not an excuse for you not to be in class. Yes, I know that there are professors that would never go to class, maybe until 2 weeks to exams, and they come and they just bombard students and they overload them. And you now go to a private university where the professor is always on time doing his work, because if he doesn't do it, he'll be graded and he'll be sacked. And those people are learning. Will you compare the knowledge of those students with one that was only taught for 2 weeks?
No.
Even if the professor graded him and gave him an A based on the 2 weeks of lectures, can you compare the two when they go to the market? So I think we need to do better by having a conscience, doing what we know is our own part, so that when we place a demand on government, we know that we're doing it from a consensus point of view. So I think we have that challenge. And I think when we're talking about the labor union, we have different labor unions and all that, but we need to have people that would be involved in public advocacy, speaking for the public. And so that's why we have some NGOs and some international non-governmental organizations that are speaking for the Nigerian people that may not be represented by any of these labor unions.
Yes.
NLC will look out for the welfare of Nigerian employees. TUC will look out for the interests of those under them. ASU will look out for the interests of her members. So we need a lot of advocacy for members of the public, and I think that can best be done by civil society organizations.
Yes.
Yes, they can do a lot in that regard. That's how we can put pressure on the government to do what they need to do for the Nigerian citizen.
How powerful is a governor?
Governor of a state?
Yes.
Well, he's the chief executive of the state.
Okay.
Yes. So, but when you say how powerful, I wish we could qualify it.
Now, I'm asking that question in regards, because an ordinary Nigerian thinks everything starts and ends with the president.
Yes.
Our governors are not held to account. And I don't know, is it true that the president is the all-powerful in Nigeria, and the president is the person to blame for all the woes and all the ills of the country?
I would say no, the president is not to blame for all the problems that we're facing as a country, but I think he should take a substantial part of the blame.
Yes, definitely.
Yes, because at that level, when he makes policies, it trickles down and affects all the other federating units. Even if a person is a local government chairman, he has a responsibility. He has a responsibility. We are all, the monies that come to them, the powers that are vested on them is to be used for public good.
Can I sue my government? So let's say a government institution. Let me take, for example, the State Water Board.
Sure.
And at what point do we draw the line between what is rightfully mine and what is rightfully ours? And can I go as an individual, or can we go as a group? And is that obtainable in Nigeria?
Let me talk about this generally. First of all, let's say you have a contract. You have a company, have a contract with, say, the State Water Board, and the State Water Board is not performing its own part. You can sue the State Water Board.
To what court?
It depends on the subject matter.
Okay, so for instance,
if it's a simple contract.
I've been paying for water and they've not been delivering water.
Oh, they've not been delivering water. You've been paying for water. I want to sue. So basically, you can sue them to the State High Court.
The State High Court.
Yes.
Okay.
But then you also have something that we call class action.
Okay.
When the action or inaction of a particular individual or a government agency affects a whole group of people, and you might not be able to easily number that people or the people there, what should be instituted is a class action. Okay. That is, see, you're maintaining this action for the class of people affected by this act. Sorry, by this action or inaction of government and all that. So
what is a class action?
A class action is an action that is done on behalf of the members of a particular group. It is different from what we normally call representative action. Let's say we have 15 people that are affected by a particular action or inaction, and we want to now ask 2 of them to represent us, to sue on our behalf.
Yes.
That is a representative action. But you can define the number of people affected. We have 15 people, for example.
Yes.
But let's say we have all the people living in Just Not, or all the people living in Yingi, all the people living, in a particular area. So that's a class action, because it's difficult for you to define the number of people that are there. So there are conditions that must be fulfilled, for you to, and so these are certain kind of actions that NGOs should be taking.
So is that in class action? Is it done in court, or where
it's
in
court?
Okay.
You go to court and you maintain, you institute that action as a class action.
Okay.
Yes, but there are conditions that the court would give you to be sure that you can actually, that this lawyer can actually handle this class action. For example, you must show, first of all, you would want to know that you have the skill, you have the resources. And so there are conditions that the court will impose on you to be sure that you can actually prosecute that class action to conclusion. Because the outcome of the matter, if you don't conduct it well, the outcome of the matter is going to be final on the people affected, and they may not be able to go and reinstitute the matter again. So that's why there are those safeguards there. But for personal wrongs, you can certainly sue any government agency. You can sue Plateau State government. You can sue the Federal Republic of Nigeria. You can sue any agency of government, and you look at the subject matter. There's what we call subject matter jurisdiction.
Yeah.
So if you want to go to a particular court, you look at what is the subject matter, what is the issue in dispute. Then you now know the appropriate court to go to get redress. So, for example, if it's a federal government agency, and maybe let's say NIMSI refuses to give you an NIN.
Yes.
Now, NIMSI is a federal government agency, and you are challenging the decision of a federal government agency. You go to the Federal High Court. But if you have a contract with the same NIMSI, and you were to supply them, let's say, computers, and after you supply them computers, they were supposed to pay on a certain date and they don't pay you, that's a simple contract. So you go to the State High Court because of the subject matter. So you need to look at the subject matter for you to determine the jurisdiction of the court. Let me say this. There is one thing that every good lawyer should do before instituting an action in court. He must be sure of the court that is clothed with jurisdiction to entertain the matter before he does that. Because sometimes you can go to court and the matter will be thrown out on the ground of jurisdiction.
The reason I ask that question is because I don't think Nigerians are suing the government enough. That is why we have decay in almost every arm of our government.
Yeah.
We cannot hold people accountable. Because
yes.
sometimes the problem is not the government.
Yes.
Sometimes the problem is the technocrats that are put in charge of certain departments or certain units of the society. Do you agree?
I agree. You see, and that is why let's first of all take the issue of not taking a lot of actions out in court against government. What SERAP did is public interest litigation, going to court and saying that education should be provided free and compulsory for the Nigerian child. That's public interest litigation. So that is a form of class action because they did it on behalf of all Nigerian children that are not in school. Now, sometimes you might also have a particular government official whose action or inaction is affecting Nigerians or affecting somebody. Now, if you're going to institute such an action, you need to understand the court that has jurisdiction to institute it correctly, first of all, and then you need to institute it on time. There is an act that is called Public Officers Protection Act. If a public officer does an action that affects you one way or the other, maybe abuses his office, abuses the power on him, you have a period of 3 months within which to institute an action. If you don't bring an action within 3 months, then you are statute barred. It means that you can no longer bring this action. No matter how good your case is against that public officer, it's protecting him. And that's because if you don't put a level of protection against public officers, a person could do something, then after 5-6 years, you come and you bring an action against the person. So there is that. So people need to be aware that if a public officer does something that is wrong, you should quickly take out an action against him in court. But we also have other agencies that are responsible for dealing with the misconduct of public officers, like public officers, this ombudsman, public complaints commission, and then we have also the Code of Conduct Tribunal. We have a lot of bodies that are responsible for dealing. So citizens can also choose to take their complaints to all these public officers complaints commission, to Code of Conduct Tribunal, and to other tribunals that can investigate these matters and take disciplinary actions against this. And for example, if a judicial officer, a judge or a judicial officer does a wrong, you can also report the person to the NGC, and by doing that, you're trying to hold them to account and hold the standard high for them up there, so that they will be able they should do what they are expected to do in that office. They are holding that office to perform certain responsibilities, and so they should actually perform those responsibilities for the benefit and the interest of Nigeria. So I think we should hold them to account as much as possible, much more. And even what you're doing, I think we can call it media advocacy. Yeah, because you're trying to get people to be aware of what they should do. And I think it would not be a bad idea to have some time to really look deeply into how citizens can hold public officers to account
Yeah.
when they misconduct or they misbehave themselves in public office.
Yes. So I want to ask you a question. And this is a question that affects everybody, like especially today in the day of social media, where I can just wake up and post anything I like without censorship and it will go viral. I can even pay for it to be promoted. We have a crop of people and group called bloggers who can just come up and just share a news, whether it's verified or not verified. So take for instance, I'm a blogger and I post something about you saying that you murdered somebody or you raped somebody or you did something terrible to somebody. What should happen in that case? Should I, who is being defamed or the news is about me, whether it's true or not, should I respond to distance myself from that, or should I just keep quiet? What is the position of the law? What are the implications?
Okay, if you want to look at it from a law point of view, let's take the case of Femi Falana, Senior Advocate of Nigeria.
Okay.
And then what somebody posted about him, that this cross-dresser, Bobrisky, approached him and I think kind of asked for how much to pay so that he can get a kind of pardon, something like that. There was a scandal around that, and the person went on social media and said Femi Falana demanded for bribe from Bobrisky, and Femi Falana had to go to court to sue. It's a class of defamation called libel.
Okay.
Yes. A lot of newspapers in the past have been sued for libelous publications, because once you put a defamatory statement in writing, it becomes libel, and which is quite serious. It's different from me just saying to Cindy now that so person rapes somebody and that statement is not true. That's defamatory. But when it is put in writing, it's libel. So bloggers should learn to verify their facts. If not, they can incur liability. And I think what Femi Falana is doing is good, so that blogger or social media content creator or social media influencer should always learn to verify facts before they create a news. So I think there should be some level of censorship for every social media or a person or blogger. If not, they can have liability. The person can sue and claim damages against them.
So in the case of an accusation, if I ignore the accusation, what does it mean in law?
Okay, it doesn't mean that you've accepted. You know, some people sometimes will just feel, I don't want to bring myself so low as to respond to what this person has to say.
Yeah.
But if the person feels that any right-thinking person will know that this is not true, this is unverified news, and the person feels, I don't want to stoop so low as to even respond to the person, it's a personal decision.
Okay.
But of course, if you do not take action, then it simply means that there is nothing that can be done. You have to take action, go to court. The court will look at the facts and then make a decision, and that becomes a judgment that you can enforce against the person. And so I think it's important for people that are defamed on social media to be able to come up and say, I've been defamed. Apart from that, there is the issue of data privacy. Let's say a person takes your image. For instance, there was somebody that's, I heard, got images of naked women and was circulating on social media. So even if they had an affair with those people, that person doesn't have the right to bring those images to public space without their consent. So it's invading into their privacy.
Yeah.
So those are things that I think we need to begin to explore and to become aware of, so that people know their limits. And I do advocate for social media advocacy and blogging. It brings in a lot of information. Now when people are looking for news, they always want to check the social media.
Yeah.
Because sometimes the conventional media are trying to be politically correct.
Yeah.
And so they hide a lot of truth. That's why we have whistleblowers, so people like Sahara reporters and all that, people that would get information, leaked information to them, and they give information. People even tend to choose to follow reporters like Sahara reporters than the conventional news.
Yeah.
Because they know that some things are hidden in conventional news. So that's why I think we really need that level of media that people bring out, but you should be able to verify those things, to know that these are things that you can actually verify if you are taking up on it.
What intrigues you the most about Nigerian law? And this is very personal.
For me, I would say the way it works or doesn't work. Yes, I must be candid with you. If I'm going to answer you honestly, I would say the way it works or doesn't work. I'm afraid to say that as a lawyer, sometimes I'm intrigued by the fact that even when I can do my research, ask Prime GPT, ask AI to tell me what it thinks after I've done my own part, and there is a clear path, clearly supported by law all the way, and that even when I file the matter in court, I'm not sure of the outcome. Yeah. Until judgment is delivered, I'm not sure of the outcome. Even when I conduct my case very well, I'm not sure of the outcome. That's a matter of concern. I think if there can be a level of certainty and predictability as to the outcome of cases, it's going to improve public confidence. And it's quite simple. What is the law? What are the facts? Apply the law to the facts and get to a conclusion. Yeah. But when you begin to see rigmaroles, it's no longer clear. So now you're now saying maybe it's from the human point of view, but we now have AI. So when AI is telling you that, see, I've looked at all the database, I know you can engage AI, you can argue, you can debate with AI, you can bring in all the different perspectives, different arguments, and you'll be able to, and from the database to be able to tell that this is how this case should go. And you also add some more industry to it, and you conduct your case passionately like that, and then you still find out sometimes that the outcome is not the way that you expected. Yeah, you find that the person that wrote the judgment is looking for an excuse to avoid the application of the law the way it is in black and white. That's one of my concerns. But I do believe that with adequate pressure on the judiciary, we'll begin to have better judgments, better decisions from our courts.
Barrister Yakusak, I must say it has been a very, very interesting time chatting with you.
Thank you so much.
My knowledge about the law and how to conduct myself has broadened, and so many things have been made clear. And I am sure that for our audience, this is going to go a long way in inspiring someone to either become a lawyer or pursue a case in court without fear.
Yes.
No matter what the outcome is. But the most important thing is people
pursuing.
Yes. So that people are held to account.
And thank you very much for having me. I'm glad to be a part of this. I'll be very happy to contribute to your content if I have the opportunity. I'd like to say that even if you go to court, even if I want to close with this statement, that even when a person goes to court and the outcome seems not to be what the person expected, yet the person conducted the matter the way it should be, then know that you've added by putting pressure on the system to deliver justice. Because whoever did that has a conscience, and I doubt if such a person will sleep peacefully.
Yeah.
And so I think people should get used to going to court and asking questions. And if they're not satisfied, they should also try to appeal. And I also plead with lawyers that sometimes we should increase the quota that we give out for pro bono cases. Sometimes justice should be for all, not only for those who are rich.
Thank you for watching The Yellow Mic. My name is Kongs Shamaki. I'd like to invite you to help us reach 1,000 subscribers. Also, like this video and share it to your friends, and let me know what you think in the comment section.